I guess we're close enough. So we called to order the 24th public meeting of the Mass Gaming Commission. First item on our agenda is the approval of minutes. We have three sets, August 8, 14, and 21. Maybe we'll start out with August 8. Any comments? One thing just occurred to me when I read the question that Commissioner Stebbins read about safeguards in their expanded gaming act that would ensure proposals for development are for resort casinos and not gaming parlors. And this actually raises an issue that we haven't ever really talked about as a commission, which is there anything that we can do to really maximize the resort destination impact of these things? Obviously, the more people we pull in from out of state, the better off we are. You know, that's pure net revenue to the Commonwealth, pure economic development to the Commonwealth. And we've had a lot of conversations with various tourism industries, elements of the tourism industry, but we've never really talked to, is there any sort of strategic work that we can do or we can facilitate to try to make these facilities be even more destination than anticipated? I'm not worried about them becoming slots parlors, but can we take to the high end? And I think this probably isn't the right place to talk about that, but I would just want to sort of put that on the table. I have had some ideas about maybe there are ways we can think of strategic relationships with other dimensions of the industry. We talked about it a little bit at your forum, but I just wanted to put that on the table. Maybe we can bring that up next week for conversation. Any other thoughts on August 8th? Should we do them one at a time? Well,
yes, I suggest we do it one at a time.
You want to have a motion to accept?
Motion to accept the meeting minutes from the August 8th meeting in the Western New England University.
Any further discussion? All in favor?
Aye.
Opposed? Ayes have it. August 14th. Are there any questions?
Yes, I have a couple of questions or perhaps potential edits. Under item 9 of the minutes of August 13, it refers to item 3.4.2. I seem to recall that one of the conclusions was also to look at the federal rates for reimbursement, so I would like to insert that as part of the minutes.
Okay.
Well, what would you like inserted there, Commissioner?
The bottom line I think we talked about looking for the federal rate just as a matter of information, but at the end, I think we decided that our bottom line was going to be just to be reasonable and just leave it at reasonable. I don't remember that we were talking about looking at the federal rates
as a guideline?
As a substitute.
Yeah,
okay.
I prepared these on the, because I wasn't here.
On the
so
transcript?
I prepared them solely. Okay. That doesn't mean we can't.
No, I just remember having had a discussion about the federal rates.
Being higher than, so I'd be happy to take a suggestion as to what we put here. But
let me look at the transcript then and offer a suggestion.
Yeah, all right.
Or,
Anything else?
Yes. Page 4, project management consultant. Commissioner Zuniga stated that a meeting is scheduled. I was not in attendance of that meeting, and I knew I would not be in attendance. It's a small correction, but my statement was that there was a meeting scheduled with the commission consultants on August 22nd. Do you see that at the top of the page of page 4?
Oh, that he is scheduled to meet. That's a mistake.
Yes.
Right. No, you were not going to be there. All right.
Right. So it was, the meeting was scheduled. It did take place, but I was not part of it.
On page 3, the last paragraph, the first point was the manual should contain the introduction discussing the nature of the commission's work, blah, 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 some kind of introduction. Did we decide who's going to do that?
I was going to take a stab at it.
Okay, fine. And then number 7, there was this issue that a commission employee was prohibited forever for working for a private entity on a particular matter in which he participated as a member of the commission. I think we were going to look into that a little bit more.
Yes, and yes,
Okay, but that's, so those two things are still.
are ongoing,
hanging.
yep, are
Okay.
open.
Okay. Any other comments? Commissioner Stebbins, you referred to questions from the Western Mass Forum that were going to be forwarded to me. Did that happen? On the last page, no, sorry, page 5, sorry, top paragraph. Are there any questions that are left hanging that I haven't responded to?
No, I think we took care of, there were 3, but there was a whole series of questions from a potential surrounding community.
Yeah.
And I think our discussion was to invite that individual in to meet with
Oh, okay.
2 of us and then
Okay, fine. So
see
that's
if we
nothing.
could help answer
Okay.
them, or at least note that we probably have to address them in the regulatory
Okay,
process.
that's fine. So there's nothing hanging. Okay. All right, should we have a motion on that with one correction?
So moved.
Second?
All in favor?
Aye.
All opposed? Ayes have it. And August 21, any comments?
I'll abstain from these minutes because I wasn't here.
I don't have anything, it's fine to me. Anybody else, comments? Don't have a motion?
Motion to accept?
Second?
With Commissioner Zuniga abstaining, all in favor? Aye.
Aye.
Opposed? Nay. Ayes have it. Okay. We're down to administration, item 3A, the Executive Director Search Update. Commissioner Stebbins?
Sure, just a quick update is we agreed at, I believe, our August 14th meeting to close the posting.
Wait a minute. The ground is shifting under us here.
We will close the posting for Executive Director on September 7th. I had a call with a potential candidate yesterday, as again, I'm getting a number of the initial referrals from our folks at jury staff. I think I reported in one of our previous meetings, most of the calls to this date have been with candidates from out of state, noting our preference in finding somebody who has previous gaming commission experience. But they are doing a pretty thorough job of screening individuals, and again, I reference Commissioner McHugh's point that if it truly is an effort to land a candidate who he or she may be from out of state, that there's some responsibility on our part to, one, sell this opportunity as well as sell the opportunity and the excitement about living in Massachusetts and living in the Boston area, and again, being part of this pretty exciting effort that we're undertaking. So, that's been something I've tried to get to with the initial kind of introductory interview calls to see if they really are interested in, what's a big issue for anybody to decide, and that's whether you want to relocate to another state. So I can report that to date everybody is sincere about their interests and sincere about exploring the opportunity further. So, but have a few more introductory phone calls set up, and then we'll move ahead with scheduling time for these candidates to come to Boston and meet with us and have a more thorough discussion about some probably more detailed questions about operating the commission, the regulatory process, et cetera. But I've been very pleased with the candidates that the jury staff has so far identified for us.
So sort of an estimated schedule at this point would be?
Again, hoping to get through the initial phone calls. I would like to think within the next 2.5 weeks, and then begin to look at scheduling the on-site visits for the candidates that are strong to move on to the next
So maybe
phase.
sort of mid-September or so for interviews,
Yes.
maybe, yeah. Okay. Great. I did speak with Commissioner Stebbins about whether we have a diverse pool of candidates, and we're not doing great on that score, and both have reiterated to jury staff that that was one of the priorities that we gave them when they came up with this, and won't be satisfied if they can't meet that objective. I think we both reinforced that. There's a second issue that's come up with jury staff, which Commissioner Zuniga wanted to talk about. You want to raise that?
Yes. The question has come up relative to potential hires out of this search for other positions, and whether we would request a proposal, if you will, from jury staff as to how to compensate for additional searches or additional hires that may come up out of this search. It's just something that in the current contract, we did not stipulate, and it's something that we ought to think about.
I thought what they were looking for was whether we would be willing to compensate them if we hired somebody from the executive director search that they had surfaced
That's
for
right.
something else.
For something else, that's what I mean.
Oh, okay.
Yes,
So it's
that's
not
what I
another,
mean.
it's not a, okay.
I forget the exact terminology, but they call it a related hire.
Right, okay.
They have already done and have done and continue to do, the search for executive director, but within that pool of applicants, if you will, there may be, or not, there may be somebody who may fit in another position,
Right.
a related position. So.
Did you ask Janice whether?
I did,
Okay.
yes. And industry practice is that there would be some compensation. And it all depends on the compensation, to some degree, it all depends on the compensation up front that was for the original search. And the compensation would also be warranted to the extent that they do a lot of the additional work that goes with hiring someone. For example, there's a level of vetting, but there's also a level of guarantee, if you will, if that person doesn't work out for a position, that they themselves would conduct additional search efforts to replace that person.
Okay, well, that was the critical thing. When Commissioner Zuniga brought this up, my reaction was, if they're doing a good job on the ED search, and one issue there is this issue of a diverse pool, but if they are doing a good job on the ED search, that their fee is pretty modest compared to others that were in that bid on the job. And if we hired somebody that they surfaced and closed, we closed the loop on somebody that, for another position, saves us a lot of time and money, and I would be inclined to do it so long as it was consistent with industry practice, which I gather that it is.
It is
So,
consistent, yes.
does anybody else have thoughts about that? So should we authorize Commissioner Zuniga to negotiate an agreement with them, that words, however you and they work out?
Yeah, I think that would be the ask, subject to the approval of the commission.
Okay, so let's do that just informally.
Okay.
Authorize Commissioner Zuniga informally and then bring it
Okay.
back to us, but
Okay.
our predisposition is to go along with their suggestion. Okay?
Fair enough.
Makes sense.
Yeah. 3B, additional hires, and we have a couple of job descriptions. So I guess Commissioner McHugh, want to give us a quick update? And
There are, well, to start with the general counsel, there's a job description there that I put out for your consideration and welcome comments on that, and then ultimately approval. The next question would be, how long does the search for, if we post this, how long does it stay open? I know that we have been in the practice of putting closing dates on the searches, the postings we've made thus far. I'm not sure why we can't post a position and have the posting end when the position is filled. That's done on a number of searches that I've been involved with elsewhere, and saves the need to repost something and go through a new process if the first search ends at a dead end. So I'd recommend that if we post if we're ready to post the general counsel position, then we say that the posting remains open until the position is filled. And then the third question is whether we want to embark on a search and a screening process of some kind, but wait until the executive director is on board to make the final decision, so that the executive director can at least take a look with us at the finalists and have a say in making that judgment. I think when we talked about these top level positions, the executive level positions, the general counsel, the IEB, director of racing may be a little bit different, but at least these high ones, we had talked about the idea of teeing up a pool of screen candidates for the executive director to be able to take a position on. So those are the three issues that as I see. Is the job description okay? Do we leave the posting open until the position is filled if we go ahead and post it now? And do we proceed with getting some finalists for the executive director to weigh in so that they'd be here when he or she arrives?
Commissioner, I want to first speak to the job description. I thought it was excellent. I love your enthusiasm and your salesperson skills. In fact, I wrote a job description, and I feel like I need to go back and amend mine because it's a bit on the vanilla side. So I really appreciated reading that, and I would be encouraged as someone interested in a general counsel position to look at this and you know, really look at it with a different view after reading this. So I just want to commend you for that. I am not sure about leaving it. I would have trouble reading a posting and not knowing what the deadline was. Knowing that, okay, I know I'm interested, I have until this point to kind of do some research, finalize my package. I'm just not sure, personally, I don't think I've ever seen one that remains open until filled, but it may be common and I'm just not aware. But I'm just thinking in my own head, wow, when is this due, and how? Could it lead someone to believe that maybe the job was already filled because it's until filled, you know? In other words, it doesn't matter when you get your package in. I'm just not sure about that. And maybe it's very common and I'm just not aware. And I love your idea about the holding this, if possible, until the executive director would assist with at least have a say in the matter. I think that's an excellent idea if we're able to do that.
One thing one can do with the posting until filled is to say application deadline is X, but that the position remains open until it's filled. So that if you get somebody for some reason misses the deadline, that it's not a terminal failure. If the search collapses, you don't have to repost it. You just repost it.
That makes a lot of sense to me then.
Yeah, that was an interesting point that
Right.
Commissioner brought, because if
Right.
you also don't know whether that's right down to, is there any
Right.
point in applying, because
Right.
it's right down to the
Right.
finalists.
May not be till
Yeah.
2015.
Right. Right.
We hope not.
Any other of the reactions to those three things?
Pretty much similar. I think the job description really encapsulates a lot of what we would want, or what the legislation envisions for the general counsel. I was on the side of leaving the position open until filled, but I recognize the nuance, and I agree that to the extent possible, the ED should have the ability to gauge between a couple of these high-level candidates.
Yeah, if we can.
If
I think
we can
just
time it well.
Let the dates play out. Right now, it's teed up just about right,
Right.
if things go well in the ED search, it'll be just about right.
Yeah, so we could have an application deadline of, say, mid-October, and begin to solicit them. He or she hopefully will be aboard by then. or at least be aboard by the time we finish the processing, and have a few candidates to take a look at.
Well, leave the general counsel open till mid-October?
Have an application deadline of mid-October. I mean, it's going to be open until filled.
Right.
With an application deadline of, I'm just throwing out mid-October as a suggestion. And then we process those.
Right.
And have 3, 4, 5 finalists ready for either interview by us. At that level, it seems to me we need to do that, whoever's tasked with doing the screening, and having the executive director have an opportunity to have a say.
Well, this is really, as it has been all along, pretty much your call, because you're the one who's playing the role of GC, and it's at this stage of the game. But that, just off the top of my head, seems like a long time from now. I would have guessed you would have wanted the applications to be done at worst a month after we post it, which would be like.
Well, we're really talking about 6 weeks as opposed to 4, Mr. Chairman.
Yeah, if you're comfortable with that, it's fine with me.
Yeah, well, I've got some other things to talk about to alleviate stress.
Okay.
In a minute.
All right, fine, okay, good. Well, if you're gonna have your stress relieved, then I'm all for
Right.
this.
No, I'm
All right.
working on that.
All right, good, for about, what, 65 years? I had a couple of editorial comments. One is it refers repeatedly to casino licenses, and we don't want to forget we're talking about the slots license also. So either casino ought to switch to gaming licenses or something. I wondered whether on the primary responsibilities you might want to put in something about overseeing adherence to the ethics law rules of the commission, just to sort of.
Yeah, that should be there. I thought it was, but.
Maybe it is, maybe I missed it.
No, I'll check.
And then, on the desirable knowledge, skills, and abilities, there's really only one, the first one, which has to do with particular legal skills and experience.
Right.
And is that really right? Is that what you wouldn't be thinking of preferred something else, either preferred experience in the gaming industry or preferred experience in the regulatory business, or is it really just this wide open?
Well, that's a good question to talk about. And
Yeah.
in my view, it is wide open. That for this position, what we're looking for is somebody who has a history of managing complex transactions in the corporate and commercial area. There will be others who will have particularized knowledge. We'll get to one of those or two of those in a few minutes.
Right.
And really, we're looking for somebody who has worked in a complex environment and on the commercial side and succeeded, demonstrating in the process the kind of flexibility and ability to deal with new challenges that I think we're going to need as we move forward. And the ability to somebody with a particular kind of expertise to fill a slot within the legal office that we're trying to build. It's that kind of generalist that I think that we really need to look after the evolving business of the commission.
That's fine with me. Again, you would know, you would have a better sense of that. So basically, any lawyer pretty much who's been out in practice for 10 or 15 years could consider themselves a candidate for this.
They could consider themselves as a candidate, but any lawyer is pretty broad, Mr. Chairman. And I think. Not
me.
Right.
I'm not talking about that kind of lawyer.
But I think that complex corporate and commercial matters in a firm, legal department, or governmental agency is going to narrow the field down.
Okay, fine. I had a couple of minor edits, which I will just give to you, and you can do with as you wish. And process-wise, have we determined that you're going to play the role here?
No, we haven't determined that, and we ought to, that's the fourth one, we ought to think about that for just a second, as to whether I'll screen this person. We don't want to form a subcommittee for a variety of reasons. We could ask an outsider to do this. We could do it with me screening them with Janice's help. I suspect we'll get a fair number of resumes. I suspect that the number of resumes that we get will quickly divide itself into two classes. And so we could go that route, or we could get the help of an outside consultant to help us with this. Those are the two alternatives as I see it. And I'm indifferent. I can see benefits to both approaches. The benefits to the doing it in-house approach is that you get to see everybody, and you get to make the judgment internally. The drawback is you get to see all of them.
Right.
You have to make the judgment internally. So
It's a real time sink. I mean,
It is.
that would take up, of course, this would be, if you're talking about the middle of, well, I guess you could be seeing candidates starting any time, right? But,
you could do it on a rolling basis, and you could also, you could do it in a variety of ways.
Right. You know, my instinct would be to say getting some kind of outside help to do a preliminary culling, to receive them, do the preliminary culling, and to get a pretty substantial number for you to look at, but not have you have to take it from the top, would be in everybody's interests, including the relevant stress levels.
Can we do that without going out to bid? I mean, that's the thing that's the
Well,
thing that
we have
concerns me.
pre-qualified 3 firms.
But do we have to go through some kind of a process of soliciting? We have 3, and
Yeah.
and we could give it to one of the others who doesn't have.
Or jury staff who's in that,
Yeah.
is particularly in the legal business.
Yeah. We could. But so my question is, do we have to go out and solicit, or can we just pick one?
I think we can pick one from each of the 3 that we have pre-qualified. The proposals are pretty standard in the sense of the fee is usually commensurate or a percent of the salary if they're doing the full search. If they're doing a support function, which may be what we're envisioning here, which is what we did for the staff attorney, we could request a quote for that, and that could be done in pretty short order. As long as we can define as much as we can the specific support function, which I'm happy to take a stab at, or let you do that, or
Well, then I'd recommend to my colleagues that we quickly get somebody aboard. I'll talk with you tomorrow about what the support function I envision, which would basically be vetting the resumes that we get. I think that I would like to just look through the resumes to make sure that nothing's been missed, but all the vetting and ranking and the like be done by an outside consultant. We get a bid for that and be able to get this thing up and posted next week so we get going. Is that unrealistic?
I think that's doable.
I think that sounds great. And so let's just informally delegate you and the commissioner and you to work out that process.
Yeah. Okay, great.
And go and get posted next week. That'd be great. All right, the staff attorney.
Staff attorney, okay. We have a great pool of jury staff got about 170 applications for this. I'm not surprised at that, quite frankly, that they've whittled down to 10 that they've sent to me, and there are some terrific people in that 10. And I would like to move promptly to take the next step with them. I talked with the jury staff folks this morning and suggested that that Commissioner Cameron, who's going to need some help on this as well, and I would take a look at the 10 and pick, say, 5 or 6 that we wanted to talk to, that we would talk to those people and make a recommendation to the commission as to who to get. And that we do that pronto, subject to the background check and the other stuff before we make the recommendation to the commission. We have some really very highly qualified people. Let me say in that regard, because I wanted to take up two other pieces, one other piece, and Commissioner Cameron has another, that as I look at this position and think about what lies ahead of us, it seems to me that we want somebody who has had extensive experience in the regulatory field, that is creating, working with, massaging, changing, promulgating regulations. We are going to be in the regulation promulgating business big time for the foreseeable future. And to have somebody who's had some experience and who's achieved some success in that area is part of the job posting qualifications. And it seems to me is a really important ingredient of what we're about to do. We have not only our own regulations to do, but we have to oversee the charitable gaming regulations that we need to work with, and I've talked with trying to get that process started again, and I think we're going to have an oversight role rather than a doing role, but we still need to have somebody who has some expertise for that. So that's one piece of our legal business. A second piece of our upcoming legal business for the next foreseeable future is things like the minutes and compliance and making sure we have followed deadlines for reporting and other things that we're required to do, routine processing of Freedom of Information Act requests that don't require a lot of heavy lifting but do require some attention to detail, some of the open meeting law stuff. And there, I have a proposal that I'll make when I finish this rather windy soliloquy. And then there's a third piece that Commissioner Cameron is going to need help with, and she can speak for herself as she so ably does, but that too is going to be heavily involved with regulations and with legislative drafting from now through February 1 or 2. Commissioner, do you want to fill in there? Because we need, I think, a third person in that area.
With regard to racing, as all of you know, we will be proposing regulatory changes in keeping with the model policies of racing, which will mean assessing our regulations as they are now and drafting new regulations to adhere to those model policies. In addition to that, by law, we are required to analyze simulcasting and parimutuel wagering by January 1 of next year. So that's a 4-month period in which to complete that one piece, which is mandated by law. I have had some conversations with Commissioner McHugh, just talking in general about some ideas. I did have a meeting last week with an individual who has significant knowledge, has worked for the state previously in this particular area with racing regulations. And this may be someone we'd be able to hire as a consultant. I am in the process of having that individual put a proposal together for us, so I will be speaking to you all about that in the near future. In addition to that piece, which may be very helpful for our short window to meet the requirements of the, having that assessment done and having drafted new regulations along with the assessment. It may make some sense to look at this individual to assist us in a consulting capacity. In addition to that,
this person wouldn't be a candidate for the
no,
staff attorney job.
No, that is not the same individual at all, but we probably would not be able to find this specific expertise available to us who comes highly recommended in that position, to be honest.
Yeah.
That would be someone that would obviously be assisting eventually with racing, but not have the expertise to help us with this particular assignment.
Okay.
In addition to the individual, that I won't mention names because we're not there yet. This is a brand-new idea that just came to me this week. The individual came in to see me. So I'm working on that piece. And secondly, one of the contacts I made in Saratoga when I was up there for the new racing commissioner training was the staff attorney for the New York Board of wagering, racing and wagering. And there's a young woman who did apply for the staff position, who just graduated from law school, who has spent a couple of summers interning with the New York Board, and they highly recommend her. She did excellent work and has gained significant knowledge. So that may be someone we may be able to bring on as a kind of a paralegal position to assist with the short-term regulatory the work that we need to do, which is, in addition to the 4-month window, we're looking at for all of the regulatory changes we will propose. We probably only have a 5-month window if we look at where we need to be before next racing season. So this is a front burner issue, and maybe an opportunity for this young person who comes highly recommended, and I have great respect for the person recommending her. He was a presenter at the training. He was excellent. So just a couple of ideas that I will be working on quickly because of our short window here with making regulatory changes.
Good.
So let me take that and fit it into a broader scheme here. We have the staff attorney, who's a reasonably high level, 3 to 5 year, 3 to 7, 8 year person, experienced lawyer who comes in and is going to be heavily occupied with the regulatory environment and creating the regulatory environment which we live in. We have the people that Commissioner Cameron just talked about, and really there's enough work there between now and the end of January, when those regulations, if we're going to change them in time for the new racing season, have to be basically ready to go through this process that we put our Phase 1 regulations through. That's the deadline about. And there's enough work for 2 people there to do that, to revise, to take a look at, revise all the regulations, incorporate best practices, and keep us informed as we're moving forward. So there's enough work there. There's a third piece of what we're doing that requires really a first-year associate type person, and that's the minutes and some of this other regulatory compliance stuff. And I had a conversation, actually I got a broadside from Boston University a while ago, and they've created an intriguing program called a fellowship program, where you take a recent law school graduate, who would be the equivalent of a first-year associate, and in effect treat that person the way judges treat law clerks. You'd have a 1-year contract with the person for law clerk type money, and he or she comes aboard and does whatever you want him or her to do. And that's the kind of work, it seems to me, that the kinds of things I'm talking about, the minutes, the regulatory compliance, the keeping track of deadlines, that we could use some help with, particularly in a time when we're evolving into a more fully staffed legal environment, when we'll have a general counsel on board who can begin to plan what the permanent view looks like, and you have this person for a 1-year contract for relatively modest, although livable salary, and no commitment beyond that. So I would recommend that we think about, after we hire this staff attorney, pursuing this fellowship kind of thing, law clerk type thing, as well as looking at Commissioner Cameron's proposal, but that's the big picture into which these pieces fit, as I see it. We can talk more about that, but it seems to me we need to move reasonably promptly on all those fronts if we're going to do so.
Yeah, I would agree with that idea that this short-term, if you will, but intense period may be a good approach to have somebody like that. I had thought of, for all things racing / financial matters, and in my quest to understand the flow of funds as they currently work, and some of the historical of the racing statutes as they were amended, and then later were amended with our statute. I had thought of somebody as like a business analyst, but from what you're describing, if this person, paralegal or contract person, could also help in that dimension, if you will, and maybe it's a bit too ambitious, I'd be interested in that dimension. The financial, the flow of funds as they relate to racing. There's a nexus to the recommendations that we have to make in January relative to pari-mutuel wagering and all of that.
Well, the people that Commissioner Cameron's talking about probably would be able to do that.
Okay.
And in addition, if we had this basic first-year associate, he or she would be a terrific legal researcher to go through the kind of statutory evolution from the beginning of the racing statutes and trace things through. That's what these young people coming right out of law school have been trained to do and are pretty good at, and they need to learn some practical stuff of it. So between those two, it seems to me, we would be able to fill that bill as well as several others.
That's great.
It makes good sense to me, so why don't we informally say that's under your collective coordination.
Okay.
You'll go ahead and try to work out that package of people.
All right.
That sounds great.
And we'll come back with proposals for the commission before we finalize anything.
Right.
Yeah.
Yes.
Okay, great.
The Director of Investigations and Enforcement Bureau, Commissioner Cameron.
Mr. Chair, there is in your packages a job description. As I just pointed out, though, I would like to amend it to include a little more enthusiastic language. I was most impressed with that. But I would be looking for your comments with regard to that job description. And again, I think this is a position we should consider posting for sooner rather than later.
Like next week?
Yes,
Yeah.
and following in line with Commissioner McHugh's recommendation on hopefully being able to fit this position in with some input from the executive director, I think makes a lot of sense for this particular position. It is a key position for our commission. I have been working with other law enforcement leaders in this state to try to have them think about great candidates for us. So starting a little bit of a recruiting process so that we have a great pool of candidates. I think that will be most helpful to us. And I've been speaking with a number of folks from within the state and as well as our gaming consultants who have a great network also to assist with providing names of individuals who may fit the bill here.
Any comments on the job description?
I think it's an excellent and comprehensive description of what we're looking for, and emphasizes the critical importance of this position to the commission's work. I think it's pretty clear that this is a key employee and that extensive law enforcement experience and investigatory experience is essential.
Well, that is good point, because I don't think it says either one of those. I just was
If you look
curious.
at qualifications under A,
Yeah,
you know, at least 10 years management experience in complex
Right.
criminal investigations and enforcement.
Right, okay.
So we're really looking for that management-type person who
Okay.
has managed a diverse group of investigative staff. And I'll be
Yeah.
honest with you, I think what we're really looking for here, and I tried to emphasize these skills, are those communication skills and relationship skills.
right,
Because you'll be dealing with law enforcement leaders from around the world in this capacity, and especially a group of diverse stakeholders here in the Commonwealth, and those relationships are critical.
right. Yeah, that's good, you're right. Do you want to add in, under minimum qualification E, the credit check, as in addition to drug testing? I think at some point, somebody said
Yeah, we could do that,
Yeah.
that would be part of the background investigation and credit check.
Right. I think somebody said we're supposed to give
Law
people-
enforcement folks are very accustomed to that.
Yeah.
But others are not, I suspect, so.
No,
we
that's
can-
that is, though, an important point. We need to say something about credit check in there, and mine, I need to add that to mine. I didn't put that in.
Right, that's right. It's supposed to be a routine part of it, heads up to people. Okay, and is the process then, so we'll hope to get this posted next week. And again, how long do you want to post it? And how do you want to handle the process of screening?
I would go with the 6 weeks. I think that makes sense to me, and listening to Commissioner McHugh talk about a 6-week process, that made a lot of sense to me, as well as hopefully having time for an executive director to weigh in, I think makes a lot of sense. You know, I would certainly be happy to take the lead and go through a screening process, and then certainly set up interviews with someone else. I would think it would be another law enforcement executive, frankly, to assist with the process and have the finalists come before the full commission.
I think it's the same issue as we talked about with Judge McHugh. You know, you're up to your eyeballs with a lot of stuff.
Well,
Do you want to take on the
I really
process
hope
of-
to have racing issues underway, and when I give my racing report, I think you'll see that things are moving quickly with regard to racing. So I think I will have, giving this 6 weeks out to, I think I will have the time, and this is a critical position.
Yeah.
So I'd be happy to take the lead, if that's acceptable.
Well, it's fine to take the lead. The question is whether you want the same kind of support that we talked about with Commissioner McHugh.
Using a search firm to
do-
assist.
To do the initial winnowing, to receive the things, and pare it down to some substantial number for where you would then pick up the ball.
I have a question that may help answer that question. Do we anticipate a lot of resumes for someone like this? I just, you know, for general counsel,
I
there's
don't
many candidates.
anticipate nearly as many as for a general counsel. It'll be a
Uh-huh.
much smaller pool of candidates, frankly.
Okay.
One of the issues we have in the Commonwealth is the fact that retired law enforcement executives who have worked for state or municipal government are not eligible to work for another state agency.
Not that they're not eligible, but they can't be paid for it because they're on
Well-
a pension, right?
Right.
So as a practical matter, right, yeah.
As a practical matter, we will not receive in-state, those kinds of individuals. So
Right.
there'll be out-of-state and/or federal, folks with federal service who would apply for this
Or
position.
mid-career people. I mean, people who are in their 30s, you know, late 30s, 40s, who, in Massachusetts, who haven't maxed out on their pensions, and that's a
To leave their
possibility.
agency and come to another. There may be some of those. I would not anticipate a lot of those individuals.
People like to stick when they're,
They do. It's that
yeah,
uniform and
yeah.
lots of reasons why it doesn't happen
Thing,
frequently,
right,
to
right.
move from agency to agency.
You're pistol
At least not,
practice.
you know, it happens a lot more around the country. It does not happen in the Northeast very often,
interesting.
interestingly enough, a
Yeah.
cultural kind of a thing.
Okay.
Quick question.
Sure.
Is there a difference between somebody coming from this type of background and how big agency or how big a team of people they may have managed in the past. I mean, is it okay for an individual to have had success managing 10 people, or do we see the size of this bureau becoming
Well,
25 to 30, and maybe that's not what somebody's up to?
Well, we left it, I think on purpose, I left it general enough to consider all of those individuals. Do you know what I'm saying? I mean, I wouldn't rule out, just because you haven't supervised 2,000 folks, I wouldn't rule out someone with different credentials.
I have one edit that.
Thank you, Commissioner.
Sorry.
Okay, then, so do you want to have support or not? What's your?
Thank you. I guess what I'd like to say is, I'd like to have that flexibility if, for example, I end up, if for example, 3 weeks into this process, we have an inordinate amount of resumes that were not anticipated, I could at that point reevaluate if that's acceptable.
Sure.
You know, it may be the kind of thing where we get no more than 10 resumes.
Yeah.
It's just hard to say.
Yeah. Okay.
Is it important to have people from some of our stakeholders potentially included in the screening process?
Yes, I think it's always helpful to have someone from another agency assist us. Yes, I would value that experience. And like I say, I've already been reaching out to many of our stakeholders to think of good candidates and make recommendations.
Okay, great.
Can I
Sure.
insert
Yep.
on this line item? Just something I've been thinking about, also some kind of finance and accounting support in a similar venue to the staff attorney that we've talked about. More and more we'll need, you know, a staff accountant, for lack of a better term. So I would like to start drafting a job description,
Fine.
some accounts payable experience for that sort. We're going to start paying more bills, and there's going to be more need to report more timely, and I think that is becoming a necessity for us.
Great. So, good, you know the process, so,
Yeah,
yeah. go ahead. Draft up
I'll
the
come
job
back with a job description.
And we want to always remember that we do have a pool of people who have contacted. I happen to know offhand of at least one who might fit that kind of a bill.
Mm-hmm.
So we just want to make sure Janice is sensitive to this, make sure we look at the people who have already contacted us as one of the places to look. That's great. So we wouldn't, well, this jumps ahead a little bit, but our org chart is probably anticipating that the Director of Administration will not include finance, right? When there be a CFO. Is that right?
There was a memo, I believe, in the packet that articulates that from.
That was last.
Spectrum, was that last?
That was
time?
last week, I think. I just can't remember. Eileen, do you remember offhand the org charts?
I think that there is a CFO. I think there's some conversation about where we draw the line between sort of commission operations and casino and operations interacting with the casinos, but in any event, at this point in time, I mean, I do think that we are likely to move support staff and the county arena and really not be able to. Are you suggesting that we wait for a CFO to be appointed?
No, I was just thinking, if this person's going to be ultimately under the Director of Administration, then you and Commissioner Zuniga should be working, you probably should be working together on this anyway. But if this person is probably going to spin out and be underneath the CFO, then it doesn't really matter as much that the coordination be done with you. So that's the only reason I'm bringing it up. I mean, if we need it, we need it. And just a question of how much it needs to be coordinated with you, that's the only reason I was raising it.
Well, I was assuming that I'd be coordinating with,
Okay, fine.
with Eileen. We've talked a little bit about this notion of a generalist in all finance and accounting matters. You know, ultimately where he or she may end up can remain to be seen. I don't know.
Okay. Fine, so that's great. So we'll get moving on that. Okay, discussion of MGC internal policies.
There's a very brief update on this. I have not yet made the changes that we discussed last meeting before I went on vacation.
You didn't do them in your bunk
I didn't
bed?
do them in when I was at camp, but I will get to them in short order and hopefully bring back the updated version pretty soon.
Okay. And also, we agreed a couple of weeks ago to get some training on state employee relations, union rules and regs, how they
Yes.
pertain to us and so forth. And we do have that scheduled for
Yes.
for September 17th, where several people from HRD.
We're changing the date.
Oh.
It's going to be next week on the 5th.
Oh, okay, good. So it's September 5th?
Yeah.
Oh, great, okay. So, and I think everybody's been notified, but not everybody has to go, but it's important for us to understand, what what our legislation calls for and what the rules are and so on, how we deal with our racing commission employees and so forth. So that's coming. Next up is Eileen Glovsky, report from Director of Administration, and she has asked that we combine this with the consultant status report under item 5, because they kind of fit together and there's some time-sensitive issues, so I will just pass this over to you. We have decided to switch the Director of Administration, alternate the Director of Administration with the Director of Communications and Outreach every other week. They both felt they didn't really have all that much to talk about. And similar as we've talked about in our own update meetings, so if they do it every 2 weeks, they're going to be a little more substantive. So this week we'll only have the Director of Administration. All
Great.
yours.
And I think we had a little bit of a discussion about this last week, but one of the roles of the Director of Administration that I'm moving into more strongly is really the coordination of the consultants, which Commissioner McHugh has done a lot of up until this point. When I first came on board, they were up to their eyeballs in RFA 1, and it was hard to make the transition, but we're really starting to do that now, so that I will be coordinating with both the project management consultants and the gaming consultants and any others that we bring in here, and be the point person for them to the commission and for the commission back to the consultants. So hopefully that will make things a little bit easier for everyone. The first thing that we really just wanted to talk about today that I believe is in your packet is the strategic plan outline. The consultants have been kind enough to put the table of contents together for us, and we just really wanted to see if there were any topics that seemed to be missing from this. I think it's fairly in-depth, so I'll be intrigued if there's something missing. But we wanted to give the commission the opportunity to take a look at it and make sure that the things that you expected to be on this were here before we send the consultants, who actually are hard at work on drafting this as we speak. But if there's something substantive that's missing, we'd like to know about it at this point in time. Commissioner Zanika?
I don't necessarily, it's nothing necessarily missing, but I had 2 questions, if that's okay. Under part 4B, Roman numeral 13 and 14, in parentheses for as potential for internet gaming and sports betting. I'm curious as to what thought process is behind that, and why is it labeled potential?
What I could tell you is that there have been.
Introduce, sorry, want to introduce Steve?
Oh, Steve Ingus, who's coming to us from Spectrum Gaming Group, our consortium of gaming people, has been working hard on this.
I believe that there have been some very preliminary discussions regarding whether these topics would be included in the regulation package. And I anticipate that there will be ongoing discussions with the commissioners in that vein.
So this is basically a placeholder in the event, so that we don't overlook the need to have those discussions.
Yes, these are subject matters that are very active throughout the gaming industry today, and are evolving and will be evolving very speedily over the next several months.
All right, well, I'll be interested in seeing the content of that. I'm particularly interested also coming from being the representative of the commission to the treasurer's online products task force, which is also, it's, as you well know, an effort that has some track and is in a bit of a parallel, if you will.
And which Spectrum staffs.
Spectrum has also,
Right. Right.
advising them, so.
Right.
I got a second question.
Yep,
that I can
go
play
ahead.
with.
Yep.
The RFA Phase 2 process, it's item 8. I was wondering if we will be looking at scenarios or formulating scenarios as part of the this process. And maybe that hasn't been yet drafted, but I'm interested in what the ongoing thought process would be relative to that.
What do you mean by scenarios?
How we may let out, whether the strategic plan will lay out one option as here's what we should do for the RFA Phase 2 process, or whether it will lay out 2 or 3 scenarios, just to pick a number, with if we do this, here's the outcome, and if we do that, there's an outcome.
Yeah, along those lines, there'll be certain areas where there'll be various options posited in the strategic plan, certain policy issues that'll need to be decided by the commissioners on an ongoing basis. With respect to RFA Phase 2 processes, there'll be discussions and recommendations about the various aspects of an application as to what you need to look at and how the evaluation process should proceed. Those are the items that are itemized here in this outline. And the actual memo, which I've seen a draft of, expands upon those points.
If I could just expand on that, because we did have a discussion the other day, a little bit about looking forward and trying to capture some of the lessons learned from the first process. And the current thinking is that we need to have a schedule as laid out in this plan, in which we have some policy decisions early on that everybody looks at, some big issues. And maybe we won't be concrete enough to have them resolved definitively, but at least we'll see what the areas are. And then some drafting, and then looking at an appropriate point, looking at the drafting with the other policy issues that surface in the context of that drafting and weigh in on those. Another level of drafting, and then remaining policy issues, and then a final set of regs to consider, so that we can still maximize efficiency in getting through this without having everybody, spending every meeting going over things line by line, but getting the policy decisions in a context made earlier in the process and as a part of an ongoing part of the process. So we don't face what we faced last time, which was unavoidable given the speed with which we were trying to work, with basically a set of policy decisions to be made toward the end, almost in a vacuum. Then the regulations for a week and a half, and then a final decision as to things that were published. So that I think Eileen, and that kind of a protocol is what Eileen and Kathy O'Toole and Kristen Gooch are working on now to try and present for us all to approve as a protocol, but that is the sort of general before they work on it.
And to a certain extent, I think that's how we're going to be approaching the strategic plan, that our intent is that the strategic plan will be fully drafted, shall we say, on or about September 10th, and that with any associated policy decisions that need to be made would then be distributed to the commissioners for review and discussion, and then the information from that discussion would then be put back into it. So it will become.
This is
an
policy
integrated-
decisions about the strategic plan.
Yes.
Not policy decisions about
Right,
regulations
so
for
we're using
phase
that
two.
sort of a model
For
to
the-
a certain
okay,
extent,
fine.
so
Okay.
that we'll get into this habit
Right.
of having a little bit more structured interaction with the commission about the development
Okay.
of this information, so it doesn't feel like
Right.
you're getting a book that has to be reviewed and that a lot of the decisions
Right.
have been
Right.
made.
That anticipated what I was going to say. The only thing on this that under 8, RFA Phase 2 process and selection, that's really what we just got through talking about. What the strategic plan needs to tell us is, what is the process that you are going to use to write the criteria and make the decisions and so forth and so on. And this doesn't really do this. This just, this just puts out some values kind of, but it doesn't really outline what the strategic plan will give us, I think, which is the proposed process by which we will develop this decision.
Well, the proposed process will be done through the promulgation of regulations. And unlike the Phase 1
Right, but I mean, the
regulations, you will
process-
have some luxury of time.
But the process that we developed the regs is we know what the regulations are publicly, but how we go through it, how are we gonna figure out which criteria we're gonna use? What kind of a ranking system are we gonna lay out?
Right.
That's a process that we have to go through in some structured form. And
Yes, I agree.
that's what the strategic plan needs to tell us, what is that structured form gonna be, whereby we're gonna identify the critical variables in the decision-making process and then translate that into an RFA 2, which just isn't quite addressed here in that one segment. So do you understand what I'm saying? Does that make sense to
Yes,
you?
no,
Yeah.
I think I
Okay.
meant that.
Yeah, that's what you were saying.
Basically,
Yeah, saying the same
talking about the
thing.
same thing, but the protocol that I was talking about was sort of thought of as a standalone thing, but it obviously is.
Fits right there, yeah.
Fits right there,
Right.
and other pieces of this fit into the strategic plan as well.
That's a really important thing, and I think it's something that all of us are, that is really the meat and potatoes of what this is all about. What are the standards and how are we going to use them to make these decisions? And we and the public need to understand how we're going to do that. That's really a big item.
Yes. Although not articulated specifically, those items that you just mentioned should be discussed in the draft strategic plan. They should be encompassed within number 8.
Exactly. Good. That's what we're all saying, I think.
Quick question on, going back to, under page 4, 9B. Explain that a little bit for me. It talks about the interplay, topic is interplay between regulatory enforcement. Then you kick off 3 examples. Are those going to be provisions of what those other individual states have done, or lessons we can learn from them?
There'll
or-
be discussions of experiences that those various regulatory agencies had in coordinating with criminal law enforcement, the mistakes made and lessons learned kind of scenarios.
Okay. Then, I know, pick New Jersey because New Jersey has a full-time commission, Pennsylvania because they're relatively new to the market. Where does Indiana kind of fit in that category?
That I'm not sure. I could find that out, but I'm not sure.
Okay, great.
And just, I wanted to let the commission know that I am going to be meeting with PMA, who are the project management consultants, on Friday, and we're going to get to work on sort of broadening the base of how
That's the
we.
meeting, the one that I'm coming to. This one that I asked you about the other day. All right.
I'll have to check back with you.
All right.
Just to set up a meeting with them and get some training on the software, but what I would like to do is, when I come back in 2 weeks, is have a draft schedule that includes more than just the things that we have on the strategic plan, but would include the hiring that we're talking about and how those plan out, and some of the procurements that we're looking at doing. And I welcome input from all of you on other things that should be added to that plan, but so that we start to go from something that's really focused on what the consultants are doing to really a big picture view of what the commission needs to be working on over the next 18 months to 3 years.
This is a really minor thought with respect to that, but I wonder if it'd be possible at some early phase to get all of the commissioners read-only access to that plan, electronic read-only access to that plan as it evolves from time to time. I think it's helpful to know what the deadlines are and what other things are going on when, and just having that available would be an enormous help.
Let me check on that. There are some licensing issues that, around that, but I will work to see if we can, I'm sure that there's a way to accomplish that.
Okay.
So I know you have some other things to update on.
As an update, in addition to delivering the strategic plan outline, the gaming consultant team has been working on a number of items relating to the RFA Phase 1 and the completion of the strategic plan. They include such items as finalizing the RFA 1 Phase 1 application forms, including determinations relating to confidentiality of information. We are nearing completion of those form sets. Anticipate that they will be ready for the Commission's review by the end of this week. We are also in the process of completing the writing of RFA Phase 1 process instructions that are designed to accompany the RFA Phase 1 application packet. They too should be ready for completion and delivery to the Commission by the end of this week. In addition, we are evolving the timeline and table of organization on a continuing basis based on last week's discussions with various commissioners. We are preparing initial budget estimates based on the discussions relating to timeline and table of organization. We are expanding the RFA Phase 2 regulations list to include the policy decisions that will be needed for each regulation. We are developing and documenting protocol for engaging with the Commission and the legal consultants around the planning, drafting, and review of the Phase 2 regulation process. And finally, but not least in significance, we are completing the drafting of the various sections of the strategic plan, and as Eileen indicated, we are on schedule for filing that with the Commission on September 10th.
Steve, could you go back to the second to last update? Could you
The
repeat that?
protocol for engaging with the Commission
Yep.
and legal discussion, yes.
What is the timeline for that?
We're in the process of working on that. I would say that that would be done within the next, week or two, but that
Okay.
it'll be an iterative process.
Yeah,
Okay.
we've begun those discussions without
Okay.
setting a time.
And in concert with that, we've also discussed extending the consultant's contract for a second phase, which would include this, that's going on sort of in parallel. We're presuming, I think we've pretty much made the decision that we want to and can extend the consultant contract to talk to the RF2 phase, the implementation of the RFA2 phase. But that's going on right now too, right? Were you finished? And we are still thinking about, but need to close the loop pretty quickly on how we're going to do the investigations and whether we need to do an external procurement. Do we use resources already on board? Some combination of that. But that's moving. We got to. If you're going to go away for a couple weeks, right? Is that what you said?
Not until October.
Oh, okay. I thought
But
you-
no, I think within the next week or so, we'll have that nailed down about
Okay.
how we're going to approach that.
Okay. Okay, great. Anything else?
Nope. Thank you.
Thank you.
Great.
Thank you.
Could I just give before they leave, and maybe I should have done that when they were here, a preview of coming attractions for next week? Because next week, our public hearing meeting is the 10th. And that's when we get the comments on the Phase 1 regulations. Next Monday, we'll have for approval the forms that Mr. Angus was talking about. Those forms are basically, one of them is the multi-state form, so there's nothing really to change there. The Massachusetts supplement and the third one, which talks about enterprise, enterprises.
Business enterprise, yeah.
Business enterprise form. The text of that comes right out of the regulations, and there's a million ways to portray it, but it's basically in the Phase 1 regulations. The piece that they're working on now is what pieces we consider to be confidential and what pieces we don't consider to be confidential. And that is going to be ready for the commission to take a look at on Monday. We basically put it out there for comment, and we will have time to think about that over the comment period. That does not have...
This is an informal comment period, right? We just put it
That's
out
right.
there.
It's an informal comment period. It's not a statutory comment period, so it doesn't have to track the comment period that is being followed for the regulations, and we can leave it open after the regulation comment period closes. So there'll be time to consider it as we go forward. The other thing that we'll have to consider next Tuesday, is how we're going to set up the final plans for setting up this multi-location hearing that we're going to have on the 10th. The open meeting law does not apply to that in terms of the strictures that apply, so long as we do what agencies typically do at this stage, and that is simply gather information and don't deliberate. And so I will have for distribution to the committee, to the commission, later this week, a little memo that we can consider next week as to a process for processing the comments that we get on September 10th. We can talk about that next week as well, because we need to have a process to efficiently process those comments and get them turned around and get the regulations revised so that we can have them in the hands of the Secretary of State by the September 28th, so they can be published on schedule. And I think we'll have no difficulty meeting that schedule. So those two things are going to be items for next Tuesday's meeting, and I just give a heads up that they're coming, and that's the context in which they're coming.
We had a question that Janice asked me about, which someone has asked whether at the public hearing they can ask us questions, like, I guess, like clarifying what do we mean by such and such, or why did we do such and such. Is that okay within the format?
Well, I think answering questions turns the meeting into a deliberation, basically, because we'll certainly take questions, we certainly can take the questions, and at the meeting where we respond to the comments we get, answer the questions. But I think to answer the questions at that meeting would turn us into a deliberative.
Yeah, I guess now that I think about it, if it's just a clarification, what did you mean by such and such, or what does this mean? Would that be all right to?
Yeah, I think that'd be okay to respond to, but what are you?
How are you
what are
gonna
the
do
criteria
Yeah, right,
you're using
right,
for
right.
such and such, and anything that's beyond the most minor of things, I think we
Right.
can't respond to.
Right. So simple questions of clarification we can probably deal with. Otherwise, we can take questions, but we'll have to get back to them if there are things that we have to deliberate to answer.
The other question that they had was, would we put a time limit on people when they come up to make their comments?
Oh, I hope so.
Well, what I had said was reasonable in this time, rather than set a time frame in advance. But I think people were asking is, do we want to say, you can speak, but you got 10 minutes, or do we want to just manage it as we go?
It seems to me that we take a look at the volume.
Yeah,
The
right.
notice asks people to tell us that they want to be heard. Take a look at the volume, and then have some rules of order promulgated as soon as we can. It seems to me that that's the functional way to do it. Would that work?
Sure.
Yeah. And because at this point, I have no idea whether we're going to have a lot of people or a few people, or how it's going to be. And if we can be more generous if we have few, but we want to make sure everybody gets heard.
Okay.
Does that make sense?
Yeah, it's fine. We did want to make sure, apparently we were going to do it from 4 to 7 in order to make sure that we could get people after work. We ended up not posting 7 as an endpoint because we didn't want to have to sit there for an hour if there was nobody there. But we do want the public to know that we are going to run over till 6 anyway, so people who are at work until 5 can get there. Okay, anything else on that?
No.
I think we are on item 4, Racing Commission. That would be Jockey Cameron.
Thank you, Mr. Chair. That's a new role for me. First, I'd like to report on hearings that were held on behalf of the Commission earlier this month. The first matter is the matter of Abad Kabasa, a licensed jockey. This was in regard to Suffolk Stewart ruling. And just to be brief in my reporting, the Commission had issued the appellant a license to practice as a jockey in the Commonwealth of Massachusetts. The appellant participated in the 5th race, taking place on Wednesday, July 4th of 2012. The appellant's horse, number 2, entered the home stretch at the 1/16th pole. It altered its course. As a result, the appellant's course change, another horse, the number 5 horse, was crowded by the appellant's course and had to maneuver in order to avoid a collision. In this matter, we heard from both the chief steward as well as the jockey. We reviewed video of this matter, and my tentative decision is based on the findings of fact. The respondent's conduct constitutes a violation of 205 CRM 4.11(6) and Section A, B, and C. During the hearing, the evidence demonstrated that the appellant's horse did change course during the home stretch, crowded another horse, and forced it to alter its path. I, on behalf of the Commission, credited the testimony of the chief steward, Susan Walsh, as being consistent with the evidence from the tape, namely a video of the race. The appellant provided testimony in the form of his opinion as to what horse 5 did pulling out, but I believed it was clear from the video and the testimony, and my tentative decision is to uphold the decision of the Suffolk Downs Board of Stewards suspending the jockey license of the appellant for 7 calendar days. The days in which the suspension is to be served shall be determined by the stewards. To the extent that the appellant appeals the disqualification of his mount from the race in question, the Commission upholds the disqualification. Of course, the appellant will be notified of the tentative decision and his right to seek reconsideration within a 30-day period. That is the first matter that I'm reporting to the Commission. The second matter is with Marco Chavez, and this was a state police ejection. Findings of fact are as: the appellant was formally licensed as an exercise rider at Suffolk Downs on May 2004. The appellant was ejected due to an altercation which occurred on April 10, 2004. Notwithstanding the ejection, the appellant continued to receive licenses to work at Suffolk Downs, most recently during the 2007 racing season on July 2nd of 2007. The appellant was again ejected from Suffolk Downs for using a false Social Security number and false date of birth. Additionally, the appellant purportedly was not in the United States legally. In 2010, for the first time, the appellant appealed that ejection. However, he ultimately failed to show at the scheduled hearing, resulting in his appeal being dismissed with prejudice. The appellant has used different Social Security numbers and date of births on applications for racing licensure. Again, the conclusion: based on the finding of fact, the appellant's conduct constitutes a valid ground for ejection of the appellant. And my tentative decision on behalf of the Commission is to uphold the objection of the appellant, and this appellant may not seek further Commission review for a full calendar year from the date of this decision. The subject will be notified, and of course, This is a tentative decision, and again, the appellant has 30 days to seek reconsideration of that tentative decision.
So this sits, they sit for 30 days. If they don't appeal it or ask for reconsideration.
The decisions
then it
become final on
becomes
behalf of the
final, right?
commission.
And they can also waive that 30-day waiting period if they want to.
We have put a process in place that if the subject chooses not to appeal and would like to serve their suspension in a timely manner, we have a process in place
And the
which will allow
reconsideration-
that to happen.
Right, and the reconsideration would be before the full commission.
Correct, but it would not be a full hearing, it would just be any new information that the appellant chose to provide to the full commission. The third matter is a state police ejection, and this is the matter of Jose Morales Marcano. And the findings of fact are as such that the appellant was formally licensed as a jockey at Suffolk Downs. On October 2nd, 2009, the appellant was in a vehicle with a Mr. Joel Villanueva in the backside of the Suffolk Downs racetrack on October 2nd. The incident in question, the state police observed the appellant with a number of pills requiring prescription. Criminal charges were filed against the appellant due to the possession of the pills in question. However, those charges have been dismissed. The appellant has stated that the prescriptions were, most of them that he had prescriptions, but not all of them. And based on a finding of fact, the appellant's conduct did constitute a valid ground for ejection. During this hearing, I credited the testimony of the appellant that he had prescriptions for most of the drugs. The finding of credibility is made in part because the appellant does not claim to have been legally in possession of all of the drugs. There were a couple of pills in which he did not have a valid prescription. His willingness to make a statement against his own interest greatly strengthens the finding of truthfulness. I noted on behalf of the commission that the dismissal of the criminal charges against the appellant is not an exonerating factor for the appellant, but a mitigating factor. Possession of such drugs without a prescription is detrimental to racing. It indicates a violation of law and possible problem with substance abuse. However, in light of the passage of time and the appellant's honesty, some mercy may be appropriate in this matter. With regard to a finding, on behalf of the commission, I order that the objection of the appellant be upheld, but that we lift that objection immediately due to at least one instance of having prescription drugs without the prescription, and the stewards may consider this matter when he seeks a license. So at this point, we will, it's my tentative decision that we lift the ejection, which will allow the appellant to then go before the stewards for a license. This individual has never had any other issues, and I found that to be a mitigating factor also. So at this point, it's my recommendation that we lift the objection and let him proceed with a licensing process before the stewards. And again, the same, it is tentative and does have the right to appeal the tentative decision. We have one other matter, and this is a previous case in which the 30 days was, we are in the middle of that 30-day window for this decision, and this is in the matter of Walter Case. You'll see a letter from his attorney in your package. That's the law office of Jeffrey Pocaro. And in light of my tentative decision that upheld the judge's ruling in this matter, that this individual not be licensed, Mr. Case's attorney is asking that we withdraw the application and request that the denial that was published in the United States Trotting Association website be withdrawn. In other words, they are asking that for us to consider the fact that they never made application and we never held a hearing. What I thought was appropriate was that we let it be known, and you'll see an extension for filing the objection to the tentative decision. So in other words, because this settlement offer was made in the middle of the 30 days, certainly we would give the individual another couple of weeks to file any kind of objection material. But it's my recommendation that we deny the request for settlement. They did make application, and we did hold a hearing. I don't think it's appropriate to say that those things did not happen, or that we do not have a record of that. So, but in being fair to the individual, I thought it was appropriate to extend his filing time for an appeal, but that we deny the settlement offer, which is to withdraw the application and the appeal process. This is a matter, Commissioner McHugh, I think the commission should vote on the on my recommendation that we deny the settlement.
Yeah, I agree that we should vote, but my only question is, should we vote now or vote after we have all the papers?
Well, if
You
there
wanna
are
do
any
it
papers, he
Well,
may.
there may not be, but.
Correct.
The deadline is September 14, and so I guess rephrase, that's whether we should wait until after September 14 and just deal with this matter once, and either deny the request to withdraw, or
Which still allows the appellant to
file,
appeal.
right, file objections, and, or I'm really asking for what your judgment is, whether we ought to do that now, give them notice?
Well, I think that the appellant is probably looking for an answer to the settlement request before a decision to appeal my tentative decision,
Yeah.
which was why I thought it would be appropriate that we vote on the settlement piece of this.
Okay.
How do you feel about that, Commissioner?
The logic of that is impeccable. I just wonder if, I'm just unsure as to whether he's entitled to notice that we were going to vote on that today. So I would recommend that we take this up next Tuesday.
Okay, that's
And that we give council notice that we're going to do so. Whether he's got a right to be heard, we can check, but at least he's got notice that we're going to take it up next Tuesday, and then take it up next Tuesday.
We'll handle the settlement offer next Tuesday, but in the meantime, the appellant will be notified that he has additional time.
Right, and that still will give him about 2 weeks to
Yes.
file whatever papers that he wants if we reject the request to withdraw the appeal.
Okay.
Who's John Hill?
Mr. Hill is right behind us. He
Oh,
handles
hi, John.
for DPL and the former racing commissioner. Mr. Hill is the keeper of all the records, sending the letters on behalf of now the gaming commission.
Got it, thank you. Okay, so we'll
Okay,
deal with this
so we
again next
will.
week.
We
Okay.
will. Thank you. In addition to those hearings and those matters, I would like to report on, I think it's appropriate to speak of the fines that were made public this week at Suffolk Downs. And what I'd like to say is I have been briefed by track officials on the matter. Reportedly, the track and the officials are cooperating with EPA to ensure compliance, to meet those standards, and certainly on behalf of the commission, I will continue to monitor that ongoing matter.
Would it make sense to be briefed by the agency as well? They may have a different view of things.
Well, this is not a new matter, Mr. Chair. This is an ongoing, a couple of years old. Millions of dollars have been spent to mitigate the situation out at Suffolk Downs. If you think it makes some sense to talk to EPA officials, I'm sure we could do that. But this is a matter that I have been briefed on with
Right.
regard to.
I don't know a thing about this, so don't anybody take this in any way other than, complete ignorance. But in the abstract, our business now is to oversee the operations of these folks and how compliance is executed and why mistakes are made, whether they're willful or not. There's a context, it seems to me, to compliance that is something we ought to know. And the facility won't necessarily have the same perspective on their compliance, as the agency itself. So I'm sort of raising a question. We know some of the facts. We've read the newspaper, you've been briefed. I at least have never seen any of the actual paperwork. I have really no idea what really went on. But I wonder whether, as the regulatory agency, it would behoove us to understand everybody's perspective and context on what transpired here. It's
Well-
just a question.
Well,
I'm asking everybody.
would you be, as we have scheduled in our efforts to learn more about the operations which we now regulate, we are scheduled out at Suffolk tomorrow. If you'd like, I can arrange for a private briefing for all the commissioners, if you think that's appropriate, and if you think that you need additional information, we could certainly arrange for that also.
Could I offer a suggestion here? Rather than do that, which is a thoughtful, of course, way to handle it, perhaps a first step, rather than trying to do this on the fly tomorrow, would be to get the papers that were filed in court. Those are going to reveal the allegations, that reveal a lot of the information that underlay the ultimate resolution. We'll have a chance to study those, to look at them, to talk about them, to inform ourselves about the parameters of what was going on, and then, to the extent that we think we need further information, we could invite, that being a federal agency, I think we can only invite a representative of the EPA to appear in front of us and do the discussion in an open forum here where everybody can see us, but at least we'd be informed about, A, the need for further information, and B, the parameters of what we need to inquire about. We could do that in fairly short order. But I think to try to dive into a matter that's been going on, as I understand it, since 2008,
Yes.
that already has resulted in a substantial amount of investment in upgrading facilities, to try and get into the middle of that on the fly with one side and not with everybody would be a mistake, and this would be a more deliberative way to get at it. So I just throw that out for consideration.
Yeah, as I said, I'm just bringing this up because it's the first time we've ever had a situation like this where one of our regulated entities had this kind of an issue. So I think we need to think about how we handle this, and that's what I'm trying to do here. So I would imagine that the papers are like this, maybe you could guide us through.
I think the relevant papers
Okay.
can be distilled into a relatively few. We can take a look at the docket and see what the papers are, get the relevant papers and distribute them to the commission, and get fairly quickly to the meat and get through a lot of the chaff.
Okay, that'd be, so that's by way of saying that you think that it kind of does make sense for us to take an effort to look a little further into this and just to get a context.
Well, I think that preliminary look will help us understand whether it's worth a further look.
A further look, yeah, okay.
Makes sense.
Okay, great,
Okay.
so.
I agree.
I'll arrange for that.
With whoever you need to, yeah, okay, great.
One further matter, before we move on to the status of the Director of Racing, is we are in the process of finalizing some additional work for our racing consultant. We talked about this a couple of weeks ago, but now we're in a position to move forward and have her facilitate the work of a working group that we put together, And this is all with regard to best practices in racing and a roadmap for getting there. So that should be finalized this week. Commissioner
Sorry.
Zuniga, I will make sure you're well informed of this, and I'll have more to report on that by next week. I can move on to the Director of Racing search, Mr. Chair?
Yeah, just on the, do we have, this can be a yes or no, I don't need to know the details, but do we have the interagency financing stuff figured out? We weren't sure where we were getting, there was this issue of the legislation changing, there might have been a cash flow problem, you guys were looking into that, there's also the issue of the dog payments, where do all those things stand?
They are ongoing, and certain matters are resolved every week, would probably be the best way to describe the process. New issues come up every week that we ask questions, and we have had a series of meetings at the Comptroller's office to seek advice on moving forward when it comes to financial arrangements. And we've also utilized Anderson and Krieger to assist us with some issues regarding kennel payments. That is, we are making progress, but we do not have a final resolution to that matter yet, Mr. Chair.
And how about the cash flow issue, the appropriation versus the accrual of monies and so forth?
In terms of payments to cities and towns, or just the notion of the absence of the appropriation?
There was the absence of an appropriation, and we were going to look into whether that posed an issue for us, or was it just a simple cash flow issue, or we can commingle funds and it doesn't matter?
Well, the short answer is that has not been fully resolved, just
Okay.
just to support Commissioner Cameron's point. There is a fact, which is there will be an absence of an appropriation for the racing operations.
Right.
But in general, the racing operations are quote-unquote self-sustaining. There will not necessarily be additional monies needed, with the following caveat. Mostly because of the absence of this appropriation, we will likely utilize monies from this trust. And when agencies do that, there's a surcharge on trust monies versus appropriation monies that the state imposes. So there's a delta there. But there's also an allowance for a waiver. We can request a waiver because A&F may recognize that that's not the intention necessarily of that surcharge. Is that,
Right.
am I explaining myself a little
Yeah.
bit? So that matter has not yet been resolved, but
Okay.
it's ongoing.
Okay, so just somebody could keep us a note just to let us know where that's going and when it gets
What
resolved.
the conclusion that I've reached, I think, is that the flow of funds, I need to really understand the flow of funds better.
Right.
And hence, I'm looking forward to a little help from either a paralegal or a racing director or both,
Right.
frankly. And that could really be good
Right.
timing for us
Well,
to
that's-
dive into
yeah.
this.
This is something that Commissioner Zuniga brought up the other day, and since it's not time sensitive, there's no sense of any crisis problem. But a lot of people, I feel the same way, I don't really understand the funds flow within that operation. But our new ED may well, and so since it's not urgent, we probably ought to just wait and let that person help us through that, as well as there'll be the audit going on, and there may be overlap between what the auditor's audit, the transition audit is doing, so.
Yes.
But I share your just, sense of frustration a little bit, because I don't really understand how those funds flows works.
Yeah.
And it may be a situation, Mr. Chair, where there are, as part of the working group's assignment, which will be all-encompassing, we may take a look at accounts. There may be a situation where there are so many accounts because Years ago, they did not have the ability to decipher money, so they set up separate accounts. So we may have too many accounts.
Yeah.
That's right.
So all of this will be looked at as part of the overall assessment review and make
Right.
recommendations for regulating in a way, in keeping with all of the best practices, including financial best practices.
And where is the transition task force in the?
You talking
The
about the
working
audit?
group.
No,
The working group.
Your working group.
They have been identified, and we have a scheduled plan to actually have meetings next week with
great.
Ms. Ullman.
Great.
And with regard, to finish my report, with regard to the Director of Racing that we've posted for, that posting closes this week. I have scheduled interviews for next week, next Thursday. Jen Stark from the AG's office, our gaming counsel, has agreed to assist in those interviews, and we're going to move forward in a timely manner, be able to present to the full commission.
How many applicants do we have?
We received, I believe it's 9 applications to date. We will be, again, I don't want to say exactly how many interviews because the posting doesn't close until
Yeah,
the
right.
end of this week, but we'll be interviewing a couple of candidates and moving ahead with the process.
Great. So, maybe by the end of this month, we might have it. By the end of next month, possibly a little sooner, we might have somebody.
It's my intent
I bet,
to
right.
move this quickly. I think we can, and I think we've done our due diligence, and we'll be able to move ahead within the next couple of weeks.
Great. Okay. Anything else on racing business? So item 5, we've done 5A. 5B, technical and other assistance. I see now, I'm confusing this. Okay, I'm confusing this with the outreach and responses. Technical and other assistance to communities. Commissioner Stebbins, do you have any?
Sure, quick update on the Ombudsman search update. We've wrapped up our interviews. We're doing some follow-up calls to, we will be, haven't started yet, doing some calls to some references. Hopefully by the end of this week, early next week, we can narrow down the list to just a handful of finalists to present to you, Mr. Chairman, and meet with shortly after Labor Day. And out of that group, hopefully have a candidate that stands above the rest. And
So I'm sorry, this week, are you going to give me those names, or next week, did you say?
my hope is either the end of this week or early next week.
Okay.
Just doing some reference calls at this point.
Okay, great.
This was, I can tell you, we saw a great pool of candidates. As we all know, this job has responsibilities at one end that kind of morph into responsibilities that are a little bit different down the line. So we had people with strong backgrounds on both sides of the requirements, and but I think we had a good, strong pool of candidates to pick from. And in every conversation, I'll remind everybody of this, but every conversation, if there was somebody we saw with tremendous skills, and they don't necessarily become a finalist for the ombudsman position, we did have conversations with them about what their other interests may be, because certainly see some of their skills being utilized by this commission at some point down the line, as again, we kind of build this organization, go along the way and figure out what our staffing needs are going to be.
Right.
And everybody was amenable to that. I think the feeling among everybody we talked to was, the level of excitement of being in on the ground floor is something as exciting as the Gaming Commission is.
Great. A couple of other things in this area. First of all, I guess since I'm serving as the ombudsman, there were 2 I think I mentioned earlier. Suffolk Downs and Ameristar talked about. One got in touch with me. Ameristar wanted its first pre-applicant payment meeting, and Suffolk Downs has asked for its post-applicant meeting with DOT, and Suffolk Downs is now asking to meet with Environmental Affairs, and I've put all those meetings together. Collins Center and Mass Development or others that you were gonna line up? Is that, where's those in the, to be working with the ombudsman to provide services?
Yes. I think Mass Development had offered to be a part of our interview process with respect to the ombudsman candidates because of their experience in doing obviously pretty large development deals. The key person there that was not available to sit in on the interviews, but I may ask that individual to help us do some of the follow-up calls. And the Collins Center have been neglectful, but we need to circle back with them and complete our work and make the presentation before the commission here in pretty short order.
Okay. And we had talked on the 8th about the RPAs, involving the RPAs in this, and we continue to get outreach from the RPAs that they'd like to be involved, but I think we agreed on the 14th to postpone that until the ombudsman comes on board, so we're just holding all the RPAs in place until the ombudsman is in place. Okay, item 6, finance budget.
I don't have an update on the budget of this year. I will be reporting a budget to actual expenditure at the close of this month in a subsequent meeting, whether that's next meeting or the meeting after that. But I did want to mention that I've had some initial discussions with our consultants from Spectrum who are putting together the budget piece for the strategic plan. And the approach really has, as I can see it, it's just preliminary, is to take what we approved as the fiscal year budget 13 and make assumptions as to additional items or growth of certain expenditures for fiscal year 14 and 15. That's sort of what I'm starting to see as the pieces that relate to budget in the strategic plan. So we went through some itemization of line items that we may or may not have carry forward. We may have to escalate some of them. We may do away with a couple of others, and those discussions are ongoing.
Okay.
But the baseline is what we already had as the fiscal year 13
Right.
approved budget.
Okay, good. Anything else in that category? Okay, item 7, public education information, community and/or development outreach responses. I think we do have one. Commissioner McHugh, did you
Yes,
set
I
this up?
wanted to talk about this. It's in the packet. It's a letter from Charles Blanchard, the Palmertown manager. We all received this at the end of the forum that we had. Commissioner Stebbins and I talked with Mr. Blanchard about this subject, the essence of which is this, that there are a number of fire districts and water districts in cities and towns throughout the state that are of considerable, they've been around for a long time, and they have a governance structure that is independent of the governance structure of the area in which they exist. And the question, but they supply the fire protection and the water service for various cities and towns under contracts with the cities and towns and the others to whom they provide services. And so a gaming applicant, an applicant for a gaming license, in an area where water or fire service is provided by one of these independent districts would have to obtain services from those districts and would have to negotiate with them in order to get the services that were required. There was some concern on Mr. Blanchard's part about whether there would have to be a host community agreement between the gaming license applicant and these independent districts, or whether the statute contemplated a host community agreement with the city or town where the applicant was going to build the development that encompassed whatever agreements were necessary with these independent districts, and asked whether the commission could clarify its position on that issue. Commissioner Stebbins and I, when we talked to Mr. Blanchard, told him that the host community agreement was one that was put to the vote of the city or town by the municipal authorities. The municipal authorities were defined in the statute as the mayor and city council of Albany Plan A and E charter, I think, and the board of selectmen of a town, and did not talk about these independent districts, so that the statute did not contemplate the creation of a host community agreement, so far as we could determine, between the applicant and these independent districts. Mr. Blanchard's letter requests the Gaming Commission to require a single host community agreement and no agreement between, no independent agreement between the gaming license applicant and these independent districts. Not sure that's within the commission's purview to require that. I do think that the commission could take the position, and it'd be my recommendation, and I think what we discussed with Mr. Blanchard, that the commission would look, would strongly encourage and would look favorably on an application from a city or town that included all of the necessary steps that had to be taken in order to make the license applied for a reality. And that would be an agreement with whoever was going to provide water and whoever was going to provide fire protection. So I think the commission could take the position that a single package voted on by the residents of the city or town that included all the elements necessary for successful development would be something the commission would be interested in receiving and would look favorably upon. The reason for dealing with this issue now is that there are a number of these districts throughout the Commonwealth. And the idea here would be to answer this question in the fashion I've just described or recommended or otherwise, and then post as one of our frequently asked questions the answer so that it would be available for everybody. Because this has come up more informally than Mr. Blanchard's request in other contexts. This is not the first time this question has arisen. So that's a synopsis of the issue, and our recommendation. I think I'm joined by you, Commissioner Stebbins, in the recommendation as to how to answer it. But
no, I agree with Commissioner McHugh's comments about this. I know this has been an issue on the minds of the folks in Palmer in trying to draw some resolution to it. At one point, I think we considered trying to address this through the regulatory process, but I think the statute is pretty clear in that we evaluate one host community agreement. We don't evaluate a number of different community agreements that come forth with respect to one applicant. So, clarifying this is taking this step, as Commissioner McHugh pointed out, and clarifying this so that this relates to this particular case, and we don't know if there are any other cases out there, but this would allow the community of Palmer to kind of move ahead with looking at what the components of a host community agreement would be. Any other examples, we may find issues with communities negotiating with a municipal utility company. We may find them, municipal water authorities, whatever have you, but the statute's pretty clear that it's one host community agreement that comes forward, compiles all these into one host community agreement as opposed to separate agreements to be put to the commission. So I like the idea of just simply addressing this as matter of our policy as opposed to waiting this out through the regulatory process. I'm not sure it needs that, but if we can give some simple declaration that that is the way to move forward, I think it would benefit, we know it benefits the town of Palmer in this case, and may benefit another community.
I have a question which is not meant as a disagreeing with the recommendation. I think it's sound. I'm just wondering if we have talked to, or we should talk to the Department of Public Utilities, which, at least in the case of water, does regulate these water districts. It does not for fire protection. So maybe somebody from there could have some insight as to whether reinforcing our position perhaps, or clarifying something that we may not be thinking about. I'm just kind of wondering.
Well, we surely should touch all relevant bases, and that would be, it certainly wouldn't be harmful to ask the Department of Public Utilities send them this letter and ask if they have any comment on that, and we could call them up and see if we get a quick answer on that. My sense is that this focuses solely on a host community agreement and what are the contents of it, which is not within the heart of the DPU's regulatory scheme, but it certainly does no harm to ask for their input.
Just as a way to
What would they have to say about this?
well, I don't know.
What might they have to say?
As the body that regulates, water districts, I'm wondering if there's a nuance that in our thinking about host community and the legislation of 23K, we may not be considering. That's all. Maybe it's overly conservative, but I was, as you were talking about, especially for water, because I happen to know that they do regulate all the water providers, whether they're public or private.
Well, I agree with Commissioner McHugh. There's nothing can hurt about making the call. But I know it's hard for me to see what they do.
We'll do that promptly, and I'm sure we'll get a prompt response, and we'll
The question that occurs to me, and I haven't really thought about this very much, but we will be speccing in RFA 2 what is required of a host community agreement, above and beyond whatever is spec'd in the legislation, I'm guessing. So is there some reason, this puts up one piecemeal item that we would now preview is going to be in the RFA, one criteria for the host community agreement. Does it matter? Does it matter that we're just sort of picking and choosing a few things, or would we be better off to say, we don't really know what's all's going to be in the host community agreement.
We don't, and that's, Mr. Chairman, why I suggest we deal with this as a frequently asked question rather than some kind of a formal ruling or something. And we surely, I think, can say, I may be wrong, but I think we surely can say that we would strongly encourage a host community agreement with all of the pieces in place over a host community agreement that had a lot of loose ends. And I think that would,
Good.
But I think at the same time, that would be helpful to both the city and the town and the districts to understand that that's what we're looking for.
Yeah.
We're not looking for a series of satellites around the host community agreement that weren't a tight part of it.
Right. Yeah, and I guess there's no harm in, if random questions comes up that preview the RFA 2 and the host, our specs, if we can deal with them, we could, so there's no harm in doing that. I agree with that. Okay. But it's an important, it's an important thing for everybody to remember that although there are negotiations going on now with communities, between developers and communities, that actually, this is again something we haven't never really talked about, but in our schedule, it is understood that a referendum on a host community agreement will come after the RFA 2 is distributed, because that will have the spec that's required for the host community agreement in it. So, anyway, just highlighting that for folks. Okay.
So could we leave it that assuming DPU doesn't have anything material to say, and if it does, we'll come back and have another discussion, but assuming that it doesn't, that we will answer this question in the fashion just described, i.e. that the commission strongly encourages and will look with great favor on a host community agreement that has all of these pieces tied up in a single package.
Yep.
All right.
Sounds right to me. I forgot one thing under some item up above, technical assistance. No, it's coming up. It's coming later. Never mind. Okay. We have had often on-again, off-again conversations on how to talk to communities of vested interests that want to talk to us, whether it's a group, whether it's a bidder, prospective bidder, or a town organization that's pushing a deal or pushing against a deal. And we keep talking about how are we going to respond to these requests, several of which are pending right now. And I think Commissioner McHugh and I were meant to come up with an approach. And what we've discussed and are going to suggest that we adopt is something like this, that official committees, official parties, from municipalities or applicants, can, through our website form, can submit a request to come forward to meet with us, tell us what the agenda would be, the time that would be required, they think would be required, and that as long as there were issues that the agenda was clarification or suggestions, but not advocacy, we would invite them to come to either our regular meetings at some, we might put a regular session in where people can come, or if need be, have a special session. For example, the example I wrote down, we might have, well, forget the examples, I don't want to distract from the conversation. So, but basically the idea is if you're an official body of some sort, you're a bidder, you're a municipality, and you want to come and talk about the process, you want to get clarification, you want to ask questions, you want to make suggestions, that we will be open to doing that as long as you fill a form that lets us know what you really want. But we will not, at this stage of the game, be hosting people who want to take an advocacy position for or against any proposal. Does that say right?
It does, with the thought in mind that the advocacy for and against, there'll be a full and ample opportunity for that once we have a concrete proposal in front of us.
Right.
And so, to prevent abstract discussions about things that may never come to pass, the advocacy should be reserved for the time when we have a concrete matter before us, so we can focus on what's material and what isn't. But the clarification process and the how do we get there process and the inevitable things that come up, we'd be willing, at our discretion, after a form is filled out, to have people come and talk to us about it. That'd be the idea.
Right. Any thoughts or other issues about that?
I think it sounds great.
It makes
Okay.
sense.
Yeah, okay.
And that'd be coordinated through the Public Information Director.
Okay. Not advocacy. Okay, so we'll work up probably a revised form from what is already on there, and we can get that out to the people who have requests pending and put it up on the website for future requests. Okay, great. The item C is the discussion of the diversity inclusion forum, which I believe we have scheduled on the 19th, and that's sticking. I can't remember whether you and I discussed this or whether I just wrote this down, but I thought it might be useful to put the agenda out, or maybe on the website or somewhere for.
The flyer is posted.
Okay.
The agenda hasn't been finalized yet.
Well, I meant for comment. You know, people might want to comment on the draft agenda.
For the diversity forum?
Yeah. Doesn't grab you.
I'll talk to Ron about it.
All right,
sure.
fine, that's fine. I'm not quite, yeah, that's fine. Okay. So actually, you know what, one thing, there was a group of sort of brainstormed that helped develop that idea. We could send it out to that group to get their feedback on it.
Okay.
Okay, that's a good idea.
Okay.
Okay, the G2E conference, which is the major national trade show, trade conference for the American Gaming Association. Frank Fahrenkopf wrote me a letter, which I've given you copies of, but with several points. One is inviting us all to come to the conference. He highlighted a lot of the sections that the things that are going on there that he thought would be particularly important. There is a 2-day NCRG, the National Council on Responsible Gaming, that's 2 days before that. There are a number of tracks. He noted things like iGaming, security and surveillance, advances in gaming technology, the globalization of the marketplaces, that these are all things that particularly commissioners like we are would value, particularly in our learning curve, which continues to be fairly steep. He also invited us to participate in the program, invited me at least to participate in one or more panels if we are out there. So I think what we've pretty much decided, but I just want to make sure that this fits with everybody, is that we do want to go ahead and keep the momentum going here. There's going to be a lot going on in October. This meeting is the end of October, the end of September, beginning October. So we don't want to compromise that motion. So we probably will send 3 commissioners, have 2 here. We'll have a meeting anyway, and the commissioners who are on the road will participate by long distance. And we may also send 1 or 2 staff to the conference. So that's kind of where we've ended up, if that fits with everybody. Okay, research agenda. There were just 2 quick things. I did meet with the Secretary of Health and Human Services, who is the trustee of the Public Health Trust. And the Public Health Trust is the trust that would fund research, that may fund research, so it's very important that she be a part of our research agenda. Also, John Auerbach, who's the head of the Department of Public Health, was there. And I just shared with them our kind of preliminary thoughts about this opportunity. First of all, what the legislative mandate is to do a really comprehensive study of the socioeconomic impacts of gaming, how we have been thinking about approaching that, and how valuable we think it would be. They were very interested and suggested, and I think wisely, that we have this research advisory group that we've begun to put together, look at an RFI before we put the RFI out. So there's a representative from the lottery, there'll now be a representative from HHS and Public Health. There's several representatives from legislative committees, a bunch of people that have expressed interest in being involved in this, all of whom we're going to need their support to make it work. So I think that was a good suggestion, and we are now trying to put together that first meeting ASAP to review the RFI, which I've kind of drafted with Commissioner Zuniga and Eileen. So we'll put that together next. Hopefully that slows down the RFI a little bit, but I think it's worth doing. So we'll do that as quickly as we can the next couple of weeks. The other thing that is we had decided tacitly earlier on not to get the gaming policy advisory
Yes.
commission?
Committee.
Committee, yeah, Gaming Policy Advisory Committee, right.
Yep.
Which is a big committee that has seats reserved for licensees and host communities. And so we sort of deduced from that at first that wasn't meant to get started until we have licensees and host communities. However, the legislation also calls for the Gaming Policy Advisory Committee to advise us on the research agenda. So we think we better get that together. Most of those are gubernatorial appointments, so we're going to get in touch with the governor's office and tell him that we've got to get moving on that. And I think that's something we would kind of put under the ombudsman. The ombudsman can kind of be the staff person and the convener for the Gaming Policy Advisory Committee, so that will be coming pretty quickly.
So this group that you're describing would be the precursor, so it would be substituted by the Gaming Policy Advisory Committee?
No, the Gaming Policy, I think we should have a research advisory group, all along. I mean, this is gonna be a big project. It's gonna take a lot of expertise as well, and it's gonna cost some money, and we want the funding partners to be bought into this. So this is something separate from that. The Gaming Policy Committee they may set up their own subcommittee on research, and maybe those two would merge.
Yep.
But that's not the same. I was thinking two different things.
What are we calling the other group, or the first group?
Well, there's no capital letters.
not-
It's just ad hoc at this point, but I'm just referring to it as a research advisory
Research.
group. But it's not capital letters yet.
Yep.
Okay, anything else on research or any of these other items before we get to 10? The one thing that did come up in the last few days, we have been kind of watching with interest what's going on in Springfield, which is exciting because there's a lot of action, but also to figure out, how that comports with our plans, and is this fitting, and what do we think of the process? And all we've really seen is the newspaper reports and of what transpired. But my sense was that what we clearly care about are the transparency of this process and maximizing the competitive environment to make this happen. And anything that promotes those two goals is good. And it seemed to me that from what was transpiring in Springfield, that the process that the mayor was laying out was moving in that direction, both of those directions, which was good. But several people have been thinking about that, and I just wanted to throw it open to comments, questions, observations, anything, if you've got them.
I do have a couple of thoughts, I guess. One that struck me, I'd be interested in the process that is being described as only in a summary right now, because it's only been reported by media. So I'm a detailed person, so I'd be interested in.
I did get a call this morning from the mayor's economic development advisor to give me an update on where things stand, and I didn't get a chance to get back to him, but I will, and I will try to make sure we understand the exact details of what's going on.
Right. I mean, I guess that's a first step. I had a couple, something else, I guess, as a question or something for us to consider or ponder. But the legislation does speak about a host community. In the case of cities that are larger than 125,000 people, a host community will be the ward of that city. And I'm curious as to whether...
Unless the mayor and the city council agree to go to this full city.
Correct. So I'm wondering how that overlays with the process that we have yet to see the details about, relative to what's described in, whether the mayor and the city council have a plan for different wards, et cetera. So.
From my standpoint, I read the newspapers like we all read the newspapers. Newspapers are always interesting. But I don't have enough detail to make a judgment on any specific aspect of anything at the moment. I agree with the chairman's comments that an open, transparent process that allows the voters of the city to vote on an agreement that ultimately comes to us with full knowledge of what they're voting on, with a transparent process for formulating that agreement, with competition to the extent competition is available, is surely in keeping with the spirit of the statute. Beyond that, in terms of specific details of specific goings-on in specific communities, as I say, the newspaper reports are endlessly fascinating, but don't supply me at the moment with enough detail to understand, to take any more of a position than that, to encourage that kind of transparent, democratic process.
Right. Yeah, I agree with that, and you know, it may well be that we don't have a role beyond encouraging that process, but I think encouraging that process is an important step in that. Anything else from anybody else?
Yeah, you know, it's interesting to watch, and you know, I'm mindful of reading the. I'm getting most of my information at this point from the media as well. You know, should we entertain? I think to Commissioner Zuniga's point, learning more about, you know, if there's a formal statement about what their process is going to be. But I think when the statute was being drafted, I don't think anybody could foresee, you know, the situation that Springfield finds itself in, with multiple entities all wanting to be in one host community. But you know, again, you know, this is a process that is still unfolding. We kind of reiterate our points and hope that any municipal process mirrors how we've conducted ourselves, being transparent, being open, being, you know, allowing public input, and but keep in mind that you know, at the end of the day, we want to see a proposal which benefits the host community and addresses the criteria that we're going to evaluate a license application. Right. That's pretty well laid out in the statute.
I think that's a good point, and we're in this funny situation where we can't talk about this just offline. We can only talk about this in public. But I think you made a really good point. I mean, there's our job is to implement the letter, as well as, to the extent possible, the spirit of this legislation. This legislation has pretty clear criteria for what matters in these applications, and certainly has clear parameters about local control. That to a certain extent, you've got two somewhat conflicting issues here. But I think for us to reinforce, just as you said, the criteria that will matter to us when it comes to us will be the criteria that are in, fundamentally, that criteria which is in the legislation. Good point. Anything else? Motion to adjourn?
So moved.
Second.
In favor?
Aye.
All right, we're adjourned.